This time, let us prepare for the NAPOLCOM PNP entrance examination. In this presentation, let us talk more about the criminal justice system. Recently, we talked about crimes. In our part 1, we talk about crimes and due process. This time, let us go with the elements of crime. So what are the elements of a crime? First, there must be an act or omission. An act, it must be an overt act. It is an overt act. It's a physical act. While omission, you are oath or obliged. You are obliged to do, or you have the duty to do, but you failed to do it, or in negligence. And the second element is that the act or omission must be in violation of a law. There must be a law. There must be a law punishing such act. Otherwise, there will be no crime. Nullum crimen nulla pones in lehi. If there is no law punishing such act, then there is no crime. Third one, it's the act or omission is performed by means of dolo or culpa. If the act or omission must be accompanied by dolo or culpa. If we say dolo, means the intent, the malice, while culpa, it's the negligence or reckless imprudence. An act or commission and omission can be distinguished. An act or a commission is any bodily movement tending to produce some effect in the external world. It's being unnecessary that the same be actually produced, as the possibility of its production is sufficient. So again, the act or commission must be bodily movement. It can be an overt act, and it is not necessary that it is actual. It can be in conspiracy, conspire to commit an act. So that is in mind, or a plan setting to commit a crime. But the act must be one which is defined by the law as constituting a felony, or at least an overt act of that felony. That is an external act which has direct connection with the felony intended to be committed. So again, if we say act or commission, it refers to an overt act. An overt act, and also that act is being violated or being defined as a crime under a law. And while omission means inaction or failure to perform a positive duty which one is bound to do. There must be a law requiring the doing or performance on an act. So again, if we say omission, you have the obligation. You have the obligation, and that obligation is set by the law and failed to do it due to negligence, due to reckless imprudence. So that constitutes an omission. And also, there must be a law. There must be a law setting. There must be a law setting to be performed that act. This time, let us go with classification of crime or felonies according to the means by which they are committed. First, crime by dolo or deceit, or that is what we call as intentional crime. There is the intent. In crime by dolo or intentional crimes, the act or omission by the offender is malicious. There is malice, there is the intent. In the language of Article 3 of the Revised Penal Code, the act is performed with deliberate intent, with malice. There is evident premeditation, there is treachery. The offender, in performing the act or in incurring the omission, has the intention to cause an injury to another. So that is when it comes with dolo or deceit, there is the intent to commit a crime. There is the malice to cause an injury to another. While crime by culpa, that is fault. that is negligence. In culpable felonies, the act or omission of the offender is not malicious. No malice. The injury caused by the offender to another person is unintentional, it being simply the incident of another act performed without malice. As stated in Article 3 of the revised Penal Code, the wrongful act results from imprudence, which indicates a deficiency of action or lack of skill, and negligence, which indicates a deficiency of perception or lack of foresight. So, that is crime by culpa. Crime by culpa, it's all about negligence, about lacking foresight, failed to foresee, lack of skills. So, but without malice, so purely an accident. So, crime by dolo or intentional crime, there is the intent or the malice. While in culpa, there is no malice, it is an accident due to negligence, lack of perception, lack of foresight. So, requisites of dolo or malice. In order that an act or omission may be considered as having been performed or incurred with deliberate intent, the following requisites must concur. So, these requisites must concur in order to have dolo or malice. First, the freedom. Second, intelligence. And number 3, it's the intent. FII. FII. Freedom, intelligence, and intent. If we say freedom, it is the capacity of a person to do whatever he pleases or the ability to do whatever he wishes. When a person acts without freedom, he is no longer a human being, but a tool. Again, if we say freedom, a person has the ability to do whatever he wants, the ability to do whatever he wishes. But if a person has no freedom, or the person acts without freedom, so under compulsion, then he is no longer a human being but a tool. His liability is as much as that of that knife that wounds, or of that torch that sets a fire, or of that a key that opens a door, or of the ladder that is placed against the wall of a house in committing robbery. So, if a person acts is without freedom, then therefore there is compulsion under an irresistible force or compulsion by another, influenced by another person to do the act, or under a threat, under a grave threat. Otherwise, something may happen wrong to his family or his or her family. That is why he or she has no freedom but to do what is being commanded. So he or she is under compulsion. That person acts like a knife, like a torch, like a key, like a ladder. So, without freedom. If there is the freedom, then therefore there is liability. If there is no freedom, then therefore that person is subject to exempting circumstances. Next, number 2, intelligence. If we say intelligence refers to the rationality of the mind or the ability to know what is right and wrong, the capacity of the person to foresee the consequences of his actuations. Without this power necessary to determine the morality of human acts, no crime can exist. So again, if we say intelligence, it is to determine whether it is right or wrong. Again, intelligence refers to whether a person knows or can differentiate what is wrong from what is right. So it's the capacity of a person to foresee the consequences of his actions, of his actuations. The ability to rationalize, the ability to think. Intelligence. Without this power, necessary to determine the morality of human acts, then no crime can exist. Thus, an imbecile or the insane, and the infant under 9 years of age, as well as the minor over 9 but less than 15 years old, unless acted with meditation, acted with plan, with like, then acting without discernment, rather, if minor over 9 years old but less than 15 years old, unless acting with discernment, rather, having no criminal liability because they act without intelligence. That is under Article 12, paragraph 1, 2, and 3 of the revised penal code. That is the exempting circumstances. So if a person acted without intelligence, he or she does not know what is the right or what is wrong, or he or she does not know what is the consequences of his acts. He has no power to think, like the imbecile, the insane, the infant under 9 years old or over 9 years old but less than 15 years old, acting without discernment. Then they are exempting circumstances. They do not have the intelligence. Now, the last one is the intent. It is the purpose to use a particular means to effect such result. Intent. What's the difference between intent from motive? If we say intent, it is the purpose to use a particular means. Used a particular means to effect such result. So, the intent is using a particular means to effect such result. So, example, treachery. Treachery and evident premeditation. These are means. These are means to effect the crime. But motive, if we say motive, it is only a driving force. Driving force for a person, for the accused to commit a crime. It's only within the mind, the motive, the driving force. But driving force alone cannot convict a person unless such motive is a circumstantial evidence, can be considered as a circumstances as part of the conspiracy to commit a crime, the driving force. Now, those are the requisites in order to have a dolo or malice. So, there can be dolo or malice if there is freedom, intelligence, and intent. If there is no freedom, but there is the intelligence, the intent, then there is an exempting circumstances. Then there can be no dolo or malice if there is no freedom. If there is no intelligence, then there can be no dolo or malice. Any absence of these three requisites cannot be considered as dolo or malice.